left to political authorities to solve. But we in India, political authorities in India sometimes take comfort by being able to give our own difficult political decisions to the Supreme Court to handle. And therefore, a political question, a difficult political question, becomes a question that the Supreme Court should handle rather than the political institutions. This is another dimension and aspect of rule of law that is different here from the understanding of rule of law anywhere else in the world. So our own doctrinal necessity and our own political question, are two things that we have willingly or maybe unwillingly allowed the court to subsume in its own jurisdiction. And the court has felt uncomfortable at times and said we are going too far, too soon, and sometimes it's been bold enough to say, well, if you can't handle it, we will handle it. And I need hardly mention some very, very tricky questions that are before the court today, that the court has to decide. And I'm not surprised that the court often raps us on the knuckles and says, why don't you just file an affidavit and say what you want to do? While we hum and haw and say, well, why won't your lordship decide what is the best thing to do? Now, it's an uneasy kind of equilibrium between us and the courts. But there are times when we need better coordination with the court. And I will mention something now which is, I believe, extremely significant. And that's economic policy making. Economic policy making, not just within the country, not just domestic economic policy, but the international, global economic positions that government of India takes, or India takes, say in G20, say at the United Nations, say at the climate change conference. We make commitments. And our law doesn't require that the commitments that are made internationally should be brought back to Parliament and then legislated as law in Parliament necessarily, unless the compact that we enter into requires legislation within the country. Otherwise, treaties are, unlike the UK, treaties are part of the legal system without having to be legislated and accepted by Parliament and endorsed by Parliament. The American Senate has to endorse their treaties before those treaties become effective. The treaties become effective as far as we are concerned without that endorsement by Parliament, although as a courtesy, Parliament is informed what treaties we have entered into and what the broad parameters of those treaties are. Now today, we are entering into bilateral investment treaties. Bilateral investment treaties are part of an emerging global scenario of economic relations between sovereign states that we haven't had in the past at this level. And the consequences of entering into these treaties as a result of the management of that subject within the country can be very, very, very serious. Consequences such as the light industries arbitration, international arbitration. We could have many, many more similar arbitrations. And therefore there has to be a greater convergence between what we're doing globally and what we're doing within the country. And this, I'm afraid, is probably lacking in the present system of adjudication in our country, which I think, again, we may have something to learn from the American Brandeis brief in the Supreme Court and the economic analysis of law that the American schools have over the years developed, and how that has become a very dominant school of jurisprudence in the United States, where the economic analysis of law is basis for pronouncement of legal propositions. We also do something similar, because economic analysis is something that you cannot completely divorce from any other analysis that we do in our modern times. But we do something beyond economic analysis as well. Now, who does the best economic analysis in the country today? As we understand, it must be the Planning Commission, it must be the economic advisors to the government of India, and the think tanks, economic think tanks that exist in this country. I don't know how much of that thinking is actually filtered into decision making of the Supreme Court when the Supreme Court is deciding matters that will have implications for us, for India, globally. And I think that's something that we have to take on board, and people like you will have to reflect on this. And some of the topics today, I do believe, will have touched upon these things, moved very closely to some of these things, but clear articulation would certainly be called for. Finally, if I might just say that in deciding, whether it's the court that decides or we individuals decide for ourselves what is fair, what is just, what is right, there is a great difference between what is right and what rights you have and what is the right thing to do. And to decide what rights you have, I cannot but think of and flag for you, in my understanding, the best possible analysis that I believe we have is if you look at John Rawls' theory of justice carefully. Some of it has been criticized in the idea of justice by Amartya Sen, but I need to read that a few more times before I understand. But the broad principles of justice that's laid down in the original position in John Rawls, I would commend to you. John Rawls says that it's difficult for anybody to judge what is fair, so long as they know what their attributes are. A judge tries through his professional training to divorce himself from his own experience, personal experience, and from personal attributes to decide objectively. And not all judges are able to do this, we know. But that's what a judge's attempt is in trying to decide objectively. But most of us don't have the same training of a judge. We don't have the caliber, the capacity, the experience of a judge. And yet we have to make these choices about what is fair and what is right. And there, John Rawls has said that if you imagine a place, a room like this, in which every door is locked, and we sit in the room and someone makes us oblivious of and forgetful of what our personalities are and what our attributes are. And in that original position of ignorance, we are asked what would be the principles of justice that you would like to apply to yourself and your society when the doors open and you go out and you also discover what attributes you have. And the two principles of justice that that he provides are a very, very, very high priority to liberty, to freedom, and next to that is equality, and equality also to factor in the greatest advantage of the disadvantage. Only then can you reach the principle of equality. So I think that that's a very good touchstone, I believe, for testing our responses and reactions to the rule of law. And of course the judges would have more complicated models available to them. The second favorite talisman that I would leave to you is the work of Ronald Dworkin, who talks about a right answer. How do you get a right answer to a difficult proposition? In a hard case, how do you get a right answer? His implicit thesis is that you never get a right answer. The moment you think you have a right answer, you stop trying. So you have to keep trying to find the right answer, and that's, I believe, the scientific process as well. At any given time, based on information available to you, there is the best answer, but it is not the right answer, because the right answer could well be something else, and you have to keep trying. And in order to arrive at the right answer, there is a methodology of morality, but he calls it institutional morality as against popular morality. So popular morality is when you go and do a survey and ask people, should people be allowed to wear skirts or short shorts to a gathering like this? And popular morality will give you one answer. But the institutional morality may give you a completely opposite answer, because institutional morality goes through a similar exercise as Rawls does, which is to test in your society institutional conduct and behavior over the centuries, and then try to match them together before testing your popular morality and your immediate emotional response or reaction, subjective reaction. in order to decide what is objectively correct. This is what I believe we are faced with today. These are difficult decisions. They get distorted in democratic choice. They get distorted in the hurly-burly of elections. But elections are important, necessary, because there are certain inputs that are not available to you without elections and without contesting of ideas, sometimes extremely aggressively, sometimes extremely virtually on the edge of unwholesomeness. But ultimately, from that churning process come out certain ideas that are indicative of mass support or mass endorsement, or at least a majority endorsement of the view that you are propagating. And therefore it's necessary. But somewhere, once the election is over, we have to find time of reflection where these things have to be, these contested positions have to be examined dispassionately, more carefully, by trained minds and with enlightened people, so that we can provide to succeeding generations better answers, if not the final answers to what is right, what is wrong. Thank you very much.
Our Associate President and Senior Advocate, Mr. P.K. Rao, will give response to the beautiful ideas presented by our Chief Guest.
Thank you, Prashant. Mr. President, Anil B, Divan, Chief Guest, Hon'ble Mr. Salman Khurshid, Prashant Kumar, Yakesh Anand, distinguished colleagues, esteemed friends, ladies and gentlemen. We are indeed thankful to you, Hon'ble Mr., for presenting certain aspects which all of us need to consider seriously. We touched upon various things, and I would like to, at the outset, when we look at our topic, role of the legal profession in upholding and strengthening the rule of law. Since yesterday we have been discussing rule of law in crisis, need for radical reforms. What has emerged from discussing various sessions is this, that all is not well with the state of rule of law. Reforms are needed and needed urgently. And all the institutional governance, they need to be strengthened. Executive, the legislature, and the judiciary. We are part of the judicial administration system. The bench and the bar, they comprise this mechanism for dispensing justice. You will recall, the Advocates Act was enacted in 1961. It has completed 50 years. We are a self-governing profession. It is statutorily constituted Bar Council of India, Bar Council of various states. Just think over for a second whether we have been able to govern ourselves to the extent contemplated by those who are responsible for putting forward this proposal to have a unified bar. First to the All India Bar Committee in 1953, then the first law commission of India chaired by Mr. Surendra G. They all felt the need for a unified bar. They also wanted the bar should be a strong bar, independent bar, well informed, well equipped. But somewhere we seem to have lost our way. We have disciplinary powers to discipline the bar, but have been able to maintain discipline in the bar. Bar councils have power to train young entrants to the bar, fresh entrants, training, guidance. They badly need it, but have been able to provide it. Legal education is another important responsibility given to the Bar Council of India. Again, what is the balance sheet? Many people have expressed openly their dissatisfaction even on this area. So therefore, how do we expect the rule of law will flourish unless the bar is strong, independent, well equipped? This Bar Association of India, as the President has pointed out to you, was established a little before the Advocates Act, 1960, the association. 61 is the Advocates Act. Therefore, it is time that there is a review of the performance of this Bar Councils and the Advocates Act, the way it has been operating, and try to take some measures. I am glad the Law Minister is here. He is not one of us. He feels that he is one of us. He makes every one of us feel that he is one of us. Easily accessible, receptive to ideas. Although there are exceptional members of the Bar Council, the top law officers, chairman after chairman of Bar Council have been telling me that they don't attend meetings. That is not what we expected. Every member of the bar holding a high position goes into the legal profession to help it, to guide it, and to make it strong and independent.